A very good afternoon to you all. Welcome to this session on new criminal laws and its impact on the railway security. The Bharatiya Nyaya Sanhita, that is the BNS, introduced as part of the 2023 legal reforms, is designed to replace the Indian Penal Code and bring India's criminal justice system in line with the modern needs. This reform focuses on streamlining the criminal justice system, addressing organized crime in a general law for the first time, terrorism, and also the infrastructure security, all of which have direct implications for the railway security. India's railway network, one of the largest in the world, is a crucial lifeline for millions of passengers and freight. The protection of this network from criminal activities like sabotage, vandalism, theft, human trafficking, and terrorism is crucial for the national security. The Bharatiya Nyaya Sanhita introduces key reforms aimed at enhancing the effectiveness of law enforcement and improving accountability relevant to the railway security. Notably, the introduction of community service as a punishment for petty offences marks a significant shift towards a reformative approach to justice. This rehabilitates offenders but also provides tangible benefits to the community. The inclusion of transgender people in the definition of gender signifies a commitment to equality and protection of all individuals. BNS has reduced the usage of outdated expressions and colonial references. It consistently uses child instead of minor and person with unsound mind instead of insane, lunatic, or idiot, which were used in the IPC. The term child means any person below the age of 18 years. Earlier, it was 16 years. Defining a child clearly in the BNS 2023 provides uniformity and clarity across various sections of the Sanhita. Government property, theft of vehicle, and theft from vehicle. Various offences against women have been made gender neutral, allowing perpetrators of any gender to be penalized, and that is a big relief over the Indian Railways. Furthermore, transgender has been defined to have the same meaning as under Section 2K of the Transgender Persons Protection of Rights Act 2019. Section 2, Clause 39, consolidates definition from the Information Technology Act 2000, which is commonly known as the IT Act. It states that terms used but not defined in the BNS, but defined in the IT Act 2000 and the Bharatiya Nagrik Suraksha Sanhita 2023, which is a replacement for the CRPC, shall have the meanings respectively assigned to them in that Act and Sanhita. This streamlines the statute and avoids ambiguity regarding undefined terms. The term snatching has been explained in new edition in the BNS 2023, Section 304. The offence of mischief in Section 324 of BNS has been expanded by including causing loss or damage to any property, including the property of government or the local authority. Now have a look on the new additions in offences. 20 sections consisting of new offences have been added in the BNS 2023. A new offence has been included in Section 69 of the BNS, which includes engaging in sexual intercourse based on acts of false promises of marriage, employment, promotion, or by concealing one's identity as an offence. For the first time, organized crime has been recognized as an offence in a central legislation under Section 111 of the Sanhita, which was earlier regulated under state legislations such as MACOCA and Gujarat Control of Terrorism and Organized Crime Act 2015. Petty organized crime has also been introduced as an offence under Section 112 of the BNS 2023. Furthermore, Terrorist Act has been criminalized under the General Criminal Statute for the first time. Section 113 of the BNSS. Earlier, the Terrorist Act has been criminalized under special statutes, such as Unlawful Actions Prevention Act 1967. As far as the offences against public servants is concerned, a new proviso, clause 2 of section 195, any public servant in the discharge of the duty as such public servant is endeavouring to disperse an unlawful assembly or to suppress a riot or affray a non-cognizable offence. A new section has been added in the BNS 2023, that is the section 226, which criminalizes the attempt to commit suicide, to compel or restrain exercise of lawful power by any public servant. Mandatory minimum punishments have been introduced for 23 offences. Some such offences are organized crime and its related offences, terrorist act, theft, dacoity, dishonest misappropriation of property, etc. Additionally, community service has been introduced for the first time as a punishment for 6 specific petty offences. These are petty theft, valued under INR 5,000, with property returned by a first-time offender, defamation, public servant unlawfully engaging in trade, attempt to commit suicide, to compel or restrain exercise of lawful power of a public servant, and misconduct in public by a drunken person, and also non-appearance in response to a proclamation published under subsection 1 of section 84 of the BNSS, that is the Bharatiya Nagarik Suraksha Sahita. Now, as far as the tackling crimes against railway infrastructure is concerned, Indian Railway is considered critical national infrastructure, and its security is vital for maintaining stability and public safety. Railway tracks, stations, signalling systems, and rolling stocks are often targets for vandalism, theft, and sabotage. The BNS introduces enhanced penalties for crime against critical infrastructure, including railways, which can disrupt train services or endanger the lives of passengers. Tampering with railway signals. In the Bharatiya Nyaya Sanhita 2023, tampering with railway signal is a serious offence related to public safety. The length of this sentence can vary depending on the severity of the tampering and its consequences. If the act leads to major accidents or loss of life, the penalty could include rigorous imprisonment, fines, and in extreme cases, even more severe punishments like life imprisonment or death penalty. Under Chapter 6 of the BNS, which deals with crimes affecting human body, tampering with railway signals with intention to cause death in accidents is an offence as per Section 100. Whereas, Section 108 states that whoever does any act with such intention or knowledge and under such circumstances that if he by that act causes death, he would be guilty of murder, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. And if hurt is caused to any person by such act, the offender shall be liable either to imprisonment for life or to such punishment as is herein before mentioned. And the word he is gender neutral as specified in the BNS. As per Section 113 Clause 2, and shall also be liable to fine. In any other case, be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and shall also be liable to fine. Similarly, as per offence of nuisance listed under Chapter 15 under Section 270, a person is guilty of a public nuisance who does any act or is guilty of an illegal omission which causes any common injury, danger, or annoyance to the public, or which must necessarily cause injury, obstruction, danger, or annoyance to persons who may have occasion to use any public right. So, if a loco pilot jumps a red signal willfully and unlawfully without any valid reason, under Section 282, he has committed an offence which is punishable with imprisonment of either description for a term which may extend to 6 months, or with a fine which may extend to 1,000 rupees, or with both. As far as theft and mischief is concerned, Section 494 and 495 of the Indian Penal Code has been combined in Section 303 Clause 1 of the BNS, while the associated penalties are specified in subsection 2. For first-time convicts where the stolen property is valued under 5,000 rupees and has been returned, the new punishment of community service has been introduced. Section 303, subsection 2, outlines a distinct punitive framework for repeat offender, mandating rigorous punishment in the form of imprisonment for a term ranging from a minimum of 1 year to a maximum of 5 years, alongside a fine. This section thereby establishes a mandatory minimum sentence for theft. This framework indicates a structured approach to deterrence, emphasizing both the severity of repeated offences and the leniency towards minor first-time infractions, thereby balancing punitive measures with rehabilitative opportunities. Section 324, subsection 3 and 5 deals with mischief related to railway property. It states, quote, "Whoever commits mischief and thereby causes loss or damage to any property, including the property of government or local authority, shall be punished with imprisonment of either description for a term which may extend to 1 year, or with fine, or with both," unquote. Section 325, subsection 5 states that whoever commits mischief and thereby causes loss or damage to the amount of 1 lakh rupees or upwards shall be punished with an imprisonment of either description for a term which may extend to 5 years, or with fine, or with both. Now these provisions emphasizes the importance of public property protection, especially national infrastructure, and imposes penalties proportionate to potential harm caused by disruptions to the railway network. Now, let us come to some serious offences like terrorism and sabotage targeting our railways. A prime target for terrorist attacks, as they are a crucial component of national infrastructure, handles millions of passenger dailies and provide an avenue for mass disruption. The BNS provides a robust legal framework to deal with terrorism-related offences that involves railways. It specifies stringent punishments, including life imprisonment or death, for crimes like these. Similarly, for train bombings, the use of explosives to target trains or railway stations can cause mass casualty and panic. The BNS ensures that such offences are treated as acts of terrorism and punishable by the maximum penalties available under the law. Terrorist Act has been criminalized under the General Criminal Statute for the first time, as I stated earlier, under Section 113 of the BNS. Earlier, Terrorist Act has been criminalized under special statutes. The Section 113 of the BNS 2023 introduces the definition of a terrorist act, paralleling Section 15 of the Unlawful Activities Prevention Act 1967, and prescribes severe penalties, including death or life imprisonment. Given the substantial overlap between Section 113 of BNS 2023 and Section 15 of UAPA, an explanatory clause has been incorporated for the sake of clarity into Section 113 of BNS, which stipulates that a decision on whether to register a case under BNS 2023 or UAPA 1967 will be made by an officer of at least the rank of Superintendent of Police. As far as the empowerment of law in the BNSS 2023 will help the state government to tackle terror attempts. The government railway police will now have more powers to coordinate with the anti-terrorism units of the state governments, ensuring that any threats to railway security is addressed promptly. Now, sabotage in the recent times. This provision also encompasses acts of sabotage carried out by insurgent groups or other organizations with the aim of creating chaos and mass destruction. Sabotage, which involves deliberate actions aimed at damaging or obstructing essential operations, falls under several sections of the Bharatiya Nyaya Sanhita 2023, depending on the context and the target of the sabotage. Specifically, sabotage against public safety infrastructure or national security can be categorized as offences under public safety like those listed under Chapter 15 and national security related sections. Another welcome step in the new act or the new law, often used as a conduit for human trafficking and smuggling, especially in remote areas or across international borders. Many trafficking operations rely on the rail network to transport victims or illegal goods. The BNS introduces comprehensive measures to combat human trafficking and other forms of organized crimes that exploit the railway network, can now face more severe penalties under the BNS. The law focuses on punishing organized crime rings that exploit the railways for trafficking women, children, and vulnerable populations. Now, Section 143 of the BNS states that whoever for the purpose of exploitation recruits, transports, harbors, transfers, or receives a person or persons by using threats or using force or any other form of coercion or by abduction or by practicing fraud or deception or by abuse of power or by inducement, including the giving or receiving of payments or benefits in order to achieve the consent of any persons or persons having control over the person recruited, transported, harbored, transferred, or received, commits the offense of trafficking. Explanation 2 of this section mentions that the consent of the victim is immaterial in determination of the offense of trafficking. Section 143, subsection 2 states that whoever commits the offense of trafficking shall be punished with rigorous imprisonment for a term which shall not be less than 7 years, but which may extend to 10 years and shall also be liable to fine. Section 143, subsection 3, where the offense involves the trafficking of more than one person, it shall be punishable with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to imprisonment for life and shall also be liable to fine. Section 143, subsection 4, where the offense involves the trafficking of a child, it shall be punishable with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to imprisonment for life and shall also be liable to fine. Section 145, subsection 2, where the offense involves the trafficking of more than one child, it shall be punishable with rigorous imprisonment for a term which shall not be less than 14 years, but which may extend to imprisonment for life and shall also be liable to fine. Similarly, Section 143, subsection 6, if a person is convicted of the offense of trafficking of a child on more than one occasion, then such person shall be punished with imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life, and shall also be liable to fine. The implementation of these penalties serves as a deterrent in reinforcing the commitment to protecting marginalized groups from systematic exploitation. Now, let us have a look how BNS has addressed the offense of smuggling, which is a menace over Indian railways. Smuggling of contraband, illegal arms, drugs, or other illicit goods through the railway system has been an ongoing issue. The BNS tightens penalties for individual caught engaging in smuggling activities on railway property, including those who exploit the railway freight system. As per Section 113, Clause 4, damage to the monetary stability of India by way of production of smuggling or circulation of counterfeit Indian paper currency coin, or of any other material will be considered a terrorist act. Similarly, wildlife smuggling over Indian railways or cigarette smuggling or transportation of NDPS through trains will be an offence under section 111, which introduces the offence of organized crime. This section includes deterrent punishments for activities such as land grabbing, kidnapping, contract killing, cybercrime, extortion, trafficking of persons, goods, weapons or drugs, and financial scams. It stipulates imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment of life, and which shall not be less than 5 lakh rupees. Now these measures are crucial for railway security, as they not only discourage criminals from using the railway system for illegal activities, but also encourage law enforcement agencies to collaborate more effectively to track and apprehend offenders. Addressing cybercrimes and railway system hacking. As Indian Railways continues to modernize and operations, it becomes more vulnerable to cyber attacks. Hacking of railway systems can lead to service disruptions, security breaches, and even accidents. The Bharatiya Nyaya Sanhita introduces cybercrime provisions that are directly relevant to railway security. As far as hacking of the railway systems is concerned, tampering with digital infrastructure, including the online ticketing systems, automated signaling, is now punishable under the BNSS. This could involve hacking into the system to steal the passenger information, manipulate train schedules, or disrupt operations. A significant addition to the Bharatiya Nyaya Sanhita 2023 is Section 111, which introduces the offence of organized crime, as stated earlier. This section includes deterrent punishments for activities which are having a direct bearing to the national security. It stipulates life imprisonment or the death penalty and a fine of rupees 10 lakhs on who commits organized crime if the offence results in death for any person. The BNS defines cyber terrorism as acts intended to disrupt public order and security by attacking critical infrastructure such as the railway network. Penalties for such acts have been enhanced to deter the cyber criminals from targeting Indian railways. By criminalizing these activities for hackers to cause large-scale disruptions or security breaches. Another burning problem is snatching over Indian railways and unauthorized ticket sales. Now there is a new addition named petty organized crimes. Section 304 of the BNS introduces the specific offence of snatching, marking a notable development in our criminal law. Under this section, theft qualifies as snatching if it involves the offender suddenly, quickly, or forcibly seizing, securing, grabbing, or taking away any movable properties like mobile phones, like gold chains from an individual or in their possession. The distinction underscores the heightened aggression and immediacy associated with snatching, differentiating it from standard theft. Whoever commits snatching shall be punished with imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine. The legal provision emphasizes the need to address the increased violence and public safety concerns inherent in such offences, thereby aiming to deter such acts through stringent penalties. Section 112, Clause 1 states that whoever being a member of group or gang, either singly or jointly, commits any act of theft, cheating, unauthorized selling of tickets, unauthorized betting or gambling, selling of public examination question papers, or any other similar criminal acts is set to commit petty organized crime. Section 112, Clause 2 states that whoever commits any petty organized crime shall be punished with imprisonment for a term which shall not be less than 1 year, but which may extend to 7 years, and shall also be liable to fine. BNS introduces a new category of offences which is distinct from the broader category of organized crime. That is why these offences has been termed petty organized crime. This new classification is not reflected in existing state legislations like MACOCA or GC TOCA. Unlike organized crime, Section 112 does not require evidence of continuing unlawful activity or the acquisition of direct or indirect material benefit from the crime. Furthermore, Section 112 criminalizes other similar criminal activities, thereby leaving the scope of offences under petty organized crime for covering wider range of similar offences. This will act as a deterrent for criminals involved in such type of crimes over Indian railways. Addressing crimes of sexual harassment and assault on Indian railways, molestation are significant concerns on trains, particularly for women and vulnerable passengers. Ensuring their safety is a major focus for the railway security. The Bharatiya Nyaya Sanhita introduces stronger penalties for sexual harassment and related offences, especially when these crimes occur in public spaces like trains or railway stations. The new BNS law removes age-based distinctions in gang rape cases involving minors, mandating life imprisonment or the death penalty for those convicted of gang raping a girl under 18 under Section 70, Clause 2. Section 76 states that whoever assaults or uses criminal force to any woman or abets such act with the intention of disrobing or compelling her to be naked shall be punished with imprisonment of either description for a term which shall not be less than 3 years, but which may extend to 7 years, and shall also be liable to fine. Under Section 76 of the BNS, the offence of assault or using criminal force with the intent to disrobe has been made gender neutral. This means that the law now applies equal to both men and women as victims or perpetrators. The move towards gender neutrality ensures that the legal provisions encompasses a broader range of situations, acknowledging that both genders can be affected by or involved in these crimes. There are many victim-centric provisions in this new law. The BNS emphasizes better protection for victims of sexual violence and harassment, ensuring that they support during investigation and trials. This is particularly important in railway security, where victims might be in transit or away from their support networks. For instance, as per Section 70, Clause 2, where a woman under 18 years of age is raped by one or more persons, shall be punished with imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life, and with fine or with death, provided that such fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim. Now it is a very specific victim-centric section. Also, the Section 70 removes age-based distinctions in gang rape cases involving minors, mandating life imprisonment or the death penalty as stated earlier for those convicted of gang raping a girl under 18. Furthermore, the enhanced focus on preventing crimes against women and vulnerable passengers strengthens the overall safety of the railway environment. Similarly, as per Section 143, Clause 7, when a public servant or a police officer is involved in the human trafficking, then such public servant or police officer shall be punished with imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life, and shall also be liable to fine as stated earlier. This again is a victim-centric section. There are many sections and there are many provisions in the new law for quick and efficient justice. The sheer size of Indian Railways means that a larger number of cases related to petty crimes, theft, and other offences need to be resolved quickly to maintain the safety and security of passengers and railway infrastructures. The BNS aims to speed up the judicial process by streamlining the procedures for handling the criminal cases. This will have a significant impact on railway-related cases, ensuring that the minor offences like petty theft, pickpocketing, and other petty offences committed on train or at the railway stations are addressed swiftly, reducing the backlog of cases as well as ensuring quick justice for the victim. Now, as far as the serious crimes are concerned, for more serious offences such as organized smuggling, terrorism, or human trafficking through railways, the BNS ensures that the trials proceed efficiently, allowing for quicker resolution of cases and the prevention of further crimes. Now let's come to Chapter 11, Offences against the Public Tranquility. Rioting in railway premises. Section 191 of the BNS 2023 has combined the sections 146, 147 and 148 of the Indian Penal Code. By combining the interconnected provisions of offence and its punishment distributed in section 146 to 148 of the IPC into section 191, BNS has streamlined the provisions under the IPC. Section 191 clause 1 states that whenever force or violence is used by an unlawful assembly or by any member thereof in prosecution of the common object of such assembly, every member of such assembly is guilty of the offence of rioting. Clause 2 states that whoever is guilty of rioting shall be punished with imprisonment of either description for a term, which may extend to 2 years, or with fine, or with both. Whereas, Clause 3 states that whoever is guilty of rioting, being armed with a deadly weapon, or with anything which used as a weapon of offence is likely to cause death, shall be punished with imprisonment of either description for a term, which may extend to 5 years, or with fine, or with both. Now the punishments are getting more stringent. The enhancement of punishment period in section 191 clause 3 aligns the deterrence with the present times. Now as far as FRA is concerned, section 194 clause 1 states that when two or more persons, by fighting in a public place, disturbs the public peace, they are said to commit an affray. And as per clause 2, whoever commits an affray shall be punished with imprisonment of either description for a term which may extend to 1 month, or with fine which may extend to 1,000 rupees, or with both. The enhancement of the fine in section 194 aligns the punishment with the present time. Earlier it was rupees 500 in the IPC. Now another crime which affects the Indian Railways is the offences against property, that is theft. We have streamlined the section 378 and 379 under the IPC, thus reducing the sections in the Sanhita as compared to IPC as far as theft is concerned. The above mentioned interconnected section of IPC have been consolidated in a single section in the new law, and definitions and punishments have been provided within the same section. Section 303, clause 2, outlines a distinctive punitive framework for repeat offenders, mandating rigorous imprisonment for a term ranging from a minimum of 1 year to a maximum of 5 years, alongside a fine. This section thereby establishes a mandatory minimum sentence for theft. I repeat, mandatory minimum sentence for theft. Additionally, for the first time, offense punishment is community service. The framework indicates a structured approach to deterrence, emphasizing both the severity of repeated offences and the leniency towards minor first-time infractions, thereby balancing punitive measures with rehabilitative opportunities. Section 305 also states that whoever commits theft in any building, tent or vessel used as a human dwelling or used for the custody of property, like our railway offices, or of any means of transport used for the transport of good or passenger, or of any article or goods from any means of transport used for the transport of goods or passengers, or of idol or icon in any place of worship, or of any property of the government or of local authority, shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Section 305 of the BNS has broadened the definition of theft within a dwelling house to encompass theft involving means of transport or a place of worship. The inclusion of means of transport in Section 305 signifies a significant expansion in the legal framework addressing theft. This broadening reflects an understanding of the evolving nature of property crime and the necessity to protect a wider array of valuable assets and spaces. The potential punishment of up to 7 years imprisonment, coupled with a fine, underscores the seriousness with which these offences are regarded, aiming to deter such criminal activities. As far as robbery is concerned, it has been mentioned in Section 309. Again, by combining the interconnected provisions of offence and its punishment distributed in Section 390, 392 and 394 of the IPC into Section 309 BNS has streamlined the provisions. In all robberies, there is either theft or extortion. Theft is robbery if an order to the committing of the theft, the offender for that end voluntarily causes or attempts to cause to any person death or hurt or wrongful restraint or fear of instant death or of instant hurt or of instant wrongful restraint. Similarly, extortion is robbery if the offender at the time of committing the extortion is in the presence of the person put in fear and commits the extortion by putting that person in fear of instant death, of instant hurt or of instant wrongful restraint to that person or to some other person. Whoever commits robbery shall be punished with rigorous imprisonment for a term which may extend to 10 years and shall also be liable to fine. And whosoever in committing or attempting to commit such robbery shall be punished with imprisonment for life or with rigorous imprisonment for a term which may extend to 10 years and shall also be liable to fine. As far as dacoity is concerned, by combining the interconnected provisions of offence and its punishment distributed in Section 391, 395, 396, 399, 400 and 402 of the Indian Penal Code into Section 309, BNS has streamlined the provisions under the IPC. When 5 or more persons conjointly commits or attempt to commit a robbery, or where persons present and aiding such commission or attempt amounts to 5 or more, every person so committing, attempting or aiding is said to commit dacoity. Whosoever commits dacoity shall be punished with imprisonment for life or with rigorous imprisonment for a term which may extend to 10 years and shall also be liable to fine. If any one of the 5 or more persons who are conjointly committing dacoity commits murder, in so committing dacoity, every one of those persons shall be punished with death or imprisonment for life or rigorous imprisonment for a term which shall not be less than 10 years and shall also be liable to fine. Section 310, Clause 3 of the BNS significantly intensifies the penalty for dacoity involving murder, imposing a sentence of death life imprisonment or rigorous imprisonment for a minimum term of 10 years along with a fine. This provision reflects BNS stringent stance by mandating minimum punishment for such grave offence. This legal framework reveals a clear intention to deter organized criminal activities through severe punitive measures. The law targets group dynamics that exacerbate the threat and impact of the offence. The mandatory minimum punishment underscores the gravity with which the legal system views dacoity, particularly when it results in murder, ensuring those convicted face substantial consequences. This approach aims not only to punish but also to prevent the proliferation of such coordinated criminal acts by instilling a high level of deterrence. The Bharatiya Nyaya Sanhita introduces a modern, efficient, and comprehensive legal framework that directly impacts railways. The BNS enhances penalties for crimes against railway infrastructure, tackles terrorism and sabotage, and strengthens provision for combating human trafficking, cybercrime, and sexual harassment over Indian railways. Moreover, the law improves the operational efficiency and accountability of railway law enforcement personnel, ensuring that criminal activities targeting the railway network are addressed swiftly and effectively. By providing stricter penalties and ensuring better coordination between law enforcement agencies, the BNS contributes to a safer railway and infrastructure from a wide range of security threats. This concludes the session of the BNS 2023. Now let us shift our attentions towards implication of Bharatiya Nagarik Suraksha Sanhita, which has replaced CRPC on the railway security. The BNSS 2023 introduces significant reforms to the criminal justice system, accountability, and the protection of victims' rights. As we explore the key features of this Act and their impact to railway security, it is essential for railway security personnel at every level to understand the changes it brings. Let's dive into the salient features of the BNSS 2023. The Bharatiya Nagarik Suraksha Sanhita 2023 replaces the CRPC and introduces some very important changes. Let's begin to examine the structural changes in the Act. The CRPC had 484 sections, while the BNSS now has 531 sections. 92 new sections or clauses have been added. 177 sections have been modified to reflect current challenges. 14 sections have been removed. 35 sections emphasize the use of audiovisual and electronic means. Another 35 sections now include time-bound conditions to ensure faster resolution. The BNSS, although it is broader in scope, the relevance of BNSS to railway security can be understood through its implications on several interconnected fronts. One of the main focus areas of the BNSS 2023 is justice. Justice for the victim and for society as a whole. This victim-centric approach introduces stronger protections and support mechanisms for those impacted by crimes. BNSS 2023 strengthens the right of victims in several ways. The introduction of zero FIR and EFIR. EFIR means electronic FIR. Makes it easier for victims to report crimes. Victims will now be informed of the progress of investigations in a time-bound manner, ensuring transparency. A faster trial procedure is implemented to reduce delays. A mandatory hearing is required before withdrawing certain category of cases, protecting the interests of victims. As far as transparency and accountability is concerned, the new law places a high emphasis on transparency and accountability in law enforcement. Key reforms include videography of search and seizure activities to ensure transparency, informing certain designated individuals about the arrested persons, clear guidelines on when and how handcuffs can be used, preventing the misuse. Technology integration is also a very focused area in this new act. Digital case management, forensic labs, and police using digital devices during investigations is a part of initiative about the technology integration. In today's digital world, the BNSS 2023 takes significant steps to integrate technology into law enforcement and legal processes. It introduces electronic communication for serving summons, notices, and warrants, reducing paperwork and at the same time improving efficiency. Mandatory use of forensic evidence in certain cases, ensuring scientific accuracy in investigation, is another very good initiative undertaken through this new law. A focus on digital case management systems to streamline processes and reduce delay in the judiciary is another step in the right direction. It also focuses on increased accountability for police in general and railway police personnel in particular. Railway security involves collaboration between multiple agencies, the Railway Protection Force, Government Railway Police, and local police forces. BNSS is designed to streamline coordination across jurisdictions, which is vital for ensuring security in such a large interconnected system like India's railways. Another critical area addressed by the BNSS 2023 is improving detention and custodial practices. The law limits the duration of police custody, ensuring that investigations are conducted within a specific time frame. It brings in reforms to prevent custodial violence, holding violators accountable. Special provisions require that arrests of women are immediately communicated to their designated family or friends. It is a forward-looking legal framework aimed at creating a safer, more just and equitable society. By incorporating modern technology, addressing victim rights, and ensuring accountability, it paves the way for a robust security and justice system for all citizens of India. Understanding this transformative law will prepare us to be better enforcers of justice and protectors of the right of every railway passenger and other stakeholders. Now let's develop some clarity regarding applicability of CRPC 1973 or BNSS 2023 in different legal scenarios. What happens to proceedings pending before 1st of July 2024 when BNSS 2023 was implemented? Will they continue under the old law or switch to a new law? Now, as per section 530 of the BNSS 2023, for any ongoing proceedings that were registered or initiated before 1st of July 2024, the procedural law that will apply is CRPC 1973. These cases will continue to be governed by the provisions of the CRPC as if the BNSS 2023 had not come into force. This means that for any cases pending on or before 1st of July 2024, the old law CRPC 1973 will remain applicable until their conclusion. The introduction of the BNSS 2023 will not affect them, ensuring continuity in the justice process. Now let's come to scenario 2. From 1st July 2024, BNSS 2023 has come into force. The question arises, which procedural law will apply to proceedings initiated on or after 1st of July 2024? Any new matters that come before law enforcement agencies from 1st July 2024 onwards will be dealt with under the provisions of BNSS 2023. This includes all new complaints, FIRs and investigations initiated after this date. The BNSS will be the primary procedural law governing all such cases moving forward. Now, scenario 3. Consider the situation. An FIR is registered after 1st of July 2024, let's say on 1st August 2024, but the incident occurred before 1st of July 2024. Which procedural law will apply to this investigation or inquiry? In such cases, even though the incident occurred before 1st of July 2024, if the FIR or complaint is registered after 1st July 2024, the investigation must proceed under the provisions of BNSS 2023. As the Supreme Court has held in various rulings, procedural laws like the BNS 2023 can be applied retrospectively. Therefore, even if the crime happened before July 2024, the procedural framework to investigate and prosecute the crime will be based on the BNSS 2023 provisions. So to summarize, scenario 1, any proceedings pending before 1st of July 2024 will continue to follow the CRPC 1973. Scenario 2, from 1st July 2024, all new proceedings will be governed by BNSS 2023. And scenario 3, if an FIR is filed after 1st July 2024, even if the crime occurred before this date, the investigation or inquiry will be conducted as per the BNSS 2023. Now let's come to changes in definitions relevant to the RPF and how they differ from the provisions of the CRPC 1973. The BNSS 2023 introduces several new definitions and modifications that are crucial for the day-to-day working of RPF personnel. Let's explore the key changes and additions that will impact your duties. Let's begin by comparing the definitions under Section 2 of the CRPC 1973 and BNSS 2023. Now, several new definitions have been added to BNSS 2023, such as audio, video, electronic means, bail and bail bond, electronic communication. Victim now includes guardian or legal heir also. Special clarifications about the prevalence of special acts over the Sanhita. These changes have been introduced to modernize legal processes and increase clarity, especially in a digital era. Now let's focus on definitions related to the electronic medium and devices, which are highly relevant to RPF operations. Section 2, Clause 1. Audio, video, electronic means in the BNSS 2023 includes use of communication devices for video conferencing, recording of identification processes, search and seizure and evidence collection, transmission of electronic communication. This definition is flexible, allowing the state government to expand the scope of devices and their purpose through rules. For example, judicial custody extensions, test identification proceedings, and bail hearings can now be conducted using electronic means. This change aims to improve efficiency and streamline legal proceedings. Next, let's discuss electronic communication, Section 2, Clause 1. Electronic communication refers to the transmission or video content from one person to another or between devices. This includes mobile phones, computers, cameras, or any other electronic device. Also, it covers communication, both person to person and device to device. This provision allows the central government to notify additional devices or forms of electronic communication, ensuring that the law can evolve with future technological advancements. This flexibility ensures that future developments in communication technology are accommodated in this new law. Let's move to the changes related to bail bonds and offense categorization under Section 2, Clause 1. Bail with conditions imposed by a court or officer. Bailable offense. Offences where the accused can be released on bail as mentioned in the first schedule or other laws. Non-bailable offences. Offences where bail is not automatically granted. Bail bond and undertaking for release with surety. Bond, a personal bond for release without surety. These definitions are crucial for RPF officers when dealing with action force operate. The updated definitions in Chapter 1, titled Preliminary, provides clarity on electronic communications, bail procedures, investigations, and more, ensuring smoother and more efficient processes. By understanding and applying these definitions correctly, RPF officers can better serve the railway passenger and uphold the law in the digital age. Now, let's discuss the definitions most conducted by a magistrate apart from trial. Investigation. The entire process of gathering evidence conducted by a police officer or an authorized person. Judicial proceedings. Any proceedings where evidence is legally taken on oath. Cognizable offence. An offence where a police officer can arrest without a warrant. Non-cognizable offence. Offences where police officer cannot arrest without a warrant and where the RPF comes into play. These definitions are fundamental for the Railway Protection Force. Properly understanding the nature of an offence, whether cognizable or non-cognizable, determines the legal authority of RPF officers. We now know that an innovative addition has been made option that benefits both the convict and the society. For example, courts can assign tasks such as cleaning public spaces, assisting in local government projects, providing support in welfare programs, so on and so forth. This shift reflects the new law's focus on rehabilitation and reducing repeat offences, while helping offenders understand the importance of contributing positively to their communities. Also, by incorporating community service, BNSS 2023 aims to modernize the judicial system and enhance the role of the courts in delivering justice in a fair, efficient, and community-centered way. Now let's come to arrest of persons. In this slide, we will explore in depth the changes in GRP's power to arrest under the latest legal updates. Previously, the power of police to arrest without a warrant was governed by Section 41 and 41A of the CRPC. However, with the introduction of BNSS 2023, these sections have been consolidated into a new section, Section 35. Let's dwell into these changes. Under the old CRPC, Section 41 allowed police to arrest without a warrant if a cognizable offence was committed in their presence, or if there was credible information about the commission of a cognizable offence. Section 41A provided guidelines for arrests based on reasonable suspicion and certain conditions. With the new BNSS 2023, Section 35 now encapsulates the provisions previously under Section 41 and 41A, who are infirm or about 60 years of age when the offence is punishable with less than 3 years of imprisonment. This is a very novel feature in the victim-centric approach of the new law. Section 35 provides that arrest without warrant can be done. A police officer can arrest without a warrant if a cognizable offence is committed in their presence. If there is a reasonable suspicion, credible information, or complaint regarding a cognizable offence punishable with up to 7 years, the officer may arrest under certain conditions. For offences punishable with more than 7 years, arrest with a warrant is also permitted. Now, what are the conditions for arrest? To prevent further offences, ensure proper investigation, preserve evidence, or ensure presence in court, conditions of arrest have been defined. If the offence is non-cognizable, arrest requires a magistrate order. What are the notice requirements? If arrest isn't required, a notice directing the person to appear is issued. Now, this is another new addition. Failure to comply with the notice may lead to arrest with reasons recorded by the officer. There are certain special provisions for the infirm or elderly, as stated earlier also. Let's have a look. Prior permission from a DSP or higher is required for arresting persons who are infirm or over 60 years old for offences punishable with less than 3 years of imprisonment. The new provision ensures greater sensitivity towards elderly and infirm individuals, reflecting a balanced approach in law enforcement. Now, what are the duties of the designated police officer regarding arrest information? Let's explore these changes in detail. With the following changes. Establishment of control room. The state government must set up police control rooms at both district and the state levels. Second work which is to be done or ensured is designation of officers. Every district and every police station must have a designated officer not below the rank of assistant sub-inspector. He or she will be responsible for maintaining and displaying the arrest information. This is a very major step towards transparency and the accountability of law enforcement personnel. Information display is also mandatory. The designated officer will ensure that information about arrested persons, including their name, addresses, and the nature of the offences, is prominently displayed in digital or physical format at every district headquarters and concerned police stations. Furthermore, standardization of information display is required across all districts and police stations. Investigating officers must be aware of the designated officer and ensure, as far as inter-district communication is concerned, as per section 82 clause 2, if an arrest is made outside the issuing district, the local police officer must inform the designated officer in the person's district of residence. I repeat, the local police officer must inform the designated officer in the person's district of residence. Now let's have a look on chapter 5, arrest by a private person and procedure. So any railway employee arrest, a person who is committing a crime. This has been updated to section 40. Let's explore these changes in detail. Section 43 allowed private individuals to arrest someone committing a cognizable offence or a proclaimed offender. However, it did not specify the exact time frame for handing over the arrested person to the police. With BNSS 2023, Section 40 introduces the following changes. Firstly, under this section, a private person or persons can arrest someone who has committed a non-bailable and cognizable offence in their presence or is a proclaimed offender. Secondly, a new time limit has been specified in the new Act. They must do so promptly and hand the accused over to a police officer or take him, her, or them to the nearest police station within 6 hours. I repeat, within 6 hours, if no such officer is available. The police officer will take the person into custody if the case falls under provision 35, section 1 of BNSS, which allows arrest without a warrant or magistrate's order. If the police officer determines there are insufficient reasons to believe that person has committed an offence, the person shall be released immediately. Now, what are the practical implications? For private individuals, you have the authority to arrest someone committing a non-bailable, cognizable offence or a proclaimed offence. Ensure that the arrested person is handed over to the nearest police station or police officer within 6 hours of the arrest. For GRP officers, the practical implications are that be prepared to take into custody individuals arrested by private persons if the arrest meets the criteria mentioned under section 35 clause 1 of the BNSS. handle situations where non-cognizable offences are suspected by verifying the details provided by the arrested person. Chapter 5. Protection of members of armed forces from arrest. Under both the old CRPC and the new BNSS 2023, the protections for members of the armed forces from arrest remain likely unchanged. Let's take a closer look at these provisions. Previously, Section 45 of the CRPC outlined the protection for armed forces members from arrest while performing their official duties. This provision has not changed under BNSS 2023. The updated BNSS 2023 incorporates the same provision under Section 42. General protection. Section 42, Clause 1 states that no member of the armed force of the Union can be arrested for actions done or purported to be done in the discharge of their official duties unless consent is obtained from the central government. As far as state government's authority is concerned, Section 42, Clause 2 specifies that the state government may issue a notification to extend these protections to specific classes or categories of armed forces members charged with maintaining public order, substituting the term central government with state government for those cases. Now, central government's consent as far as the central paramilitary forces are concerned or the armed forces are concerned, arrest for action done in official capacity requires a mandatory consent from the central government. Now, what are the practical implications for law enforcement officers? Ensure that any arrest involving armed forces members is conducted in compliance with Section 42, obtaining the necessary consent from the central government. Be aware of any state government notifications that may extend these protections to additional categories of armed forces personnel. Here we will examine the updated regulations regarding the use of handcuffs during an arrest under BNSS 2023, the use of handcuffs. This has now been updated to Section 43 in BNSS 2023. Let's break down these changes and understand the new conditions. Previously, Section 46 of the CRPC did not specify detailed conditions for the use of handcuffs during arrests, except that they could be used as necessary. With BNSS 2023, Section 43, Clause 3 outlines that the police officer may use handcuffs while making the arrest or producing the arrested person before the court based on the nature and gravity of the offense. Handcuffs can be used for habitual or repeat offenders, those who have escaped from custody, individuals involved in organized crime, terrorist acts, drug-related crimes, illegal possession of arms, murder, rape, acid attacks, counterfeiting currency, human trafficking, sexual offences against children, or crimes against the state. What are the restrictions and exceptions? The new provision allows the use of handcuffs based on the gravity of the offence and also on the criminal history of the individual. What are the judicial precedents? Previously, Citizen for Democracy versus State of Assam and others judgment came into force in the year 1995. After that, the Honorable Supreme Court mandated that police would not handcuff an arrested person, and for that, permission from the court was required. Now, BNSS 2023 specifies conditions under which handcuffs can be used, reflecting practical needs while respecting the individual rights. Officers must evaluate the seriousness of the offence and the individual's criminal record to determine whether handcuffs are appropriate. Now, what are the practical implications? For GRP officers, we have to assess, evaluate the nature and gravity of the offence to decide whether handcuffs are really necessary. Then we have to ensure documentation. Ensure that the decision to use handcuffs is documented. specifying the reasons related to the seriousness of the crime or the individual's criminal history. To summarize, conditional use of handcuffs should be done. Specific crimes should be taken into account before handcuffing an arrested accused, and legal compliance should be ensured. Now we will explore the updated requirements for informing about an arrest under BNSS. Previously, Section 50A mandated that any police officer making an arrest must inform the arrested person's relatives, friends, or nominated individuals about the arrest and location where the person is being held. With BNSS 2023, Section 48 outlines the following updates. Firstly, notification requirements have to be ensured. Section 48, Clause 1 states that in addition to informing the arrested person's relatives, friends, or nominated individual, the police officer may now also inform the designated police officer in the district, as stated earlier. This designated officer is responsible for maintaining records of the arrested persons. Section 48 Clause 2 states that the arrested person, a record must be made of who has been informed about the arrest. This entry should be kept in a book at the police station in a format specified by the concerned state government. And what are the duties of the magistrate? Section 48 Clause 4 states that the magistrates before whom the arrested person is produced must ensure compliance with the notification and record-keeping requirements. Chapter 5, Procedure of Arrest, Examination of Accused by Medical Practitioner as outlined in Section 51, replacing Section 53 of the CRPC. Let's begin by comparing the old and new regulations. In the past, under Section 53 of the CRPC, a medical examination of the accused could only be requested by an officer not below the rank of sub-inspector. Whereas, under Section 51 of the new law, the following changes have been introduced. Firstly, any police officer can request examination. Unlike the old CRPC, where only officers above the rank of or of the rank of sub-inspector could make the request. Any police officer can now request a registered medical practitioner, I repeat, a registered medical practitioner to examine the accused. The registered medical practitioner must promptly forward the examination report to the investigating officer without any delay. Now, there is a clarification on registered medical practitioner. That is why I repeated this term. Registered medical practitioner is defined as someone who holds a qualification recognized under the National Medical Commission Act 2019 and is listed in the National Medical Register or a state medical register. There are also specific requirements for the female accused. When a female accused is to be examined, the examination must be conducted only by a female registered medical practitioner or under her supervision. Now this is mandatory. Here, we will be discussing the important procedure of identifying a person arrested as per Section 54 of the BNSS 2023. Replaces the previous Section 54A of the CRPC with several key updates. In the CRPC, Section 54A outlined the process for identifying an arrested individual with specific provisions when the identifying person was mentally or physically disabled. In the new law, this has been updated under Section 54 with added responsibilities for ensuring a fair and respectful process. Let's break down the key updates under Section 54. When a person is arrested and the identification is necessary for an investigation, the court, upon request from the police, may direct the arrested person to submit to an identification process. There are special provisions for differently abled persons. If the person identifying the arrested individual is mentally or physically disabled, the identification process must be conducted under the supervision of a magistrate. In the CRPC, this responsibility was held by a judicial magistrate, but in the new law, it applies to any magistrate with jurisdiction. There is also a mandatory condition about the audio-video recording of the process. In CRPC section 54A, the identification process for differently abled individuals had to be videographed. Now under section 54, the process must be recorded using audio-video electronic means. So it is not restricted to only videography, allowing for more comprehensive documentation. With the introduction of audio-video recording in this process, it is essential that law enforcement officers use modern tools and equipment to ensure a complete and accurate record of the identification. Arrested without a warrant as per section 58 of the BNSS 2023, which replaces section 57 of the CRPC. Previously, under section 57 of the CRPC, an arrested person could not be detained for more than 24 hours without being presented to a magistrate unless special orders were obtained under section 167. In the new law, this rule has been reaffirmed with some important updates under section 58. There is a time limit for detention. No police officer is allowed to detain a person arrested without a warrant for more than 24 hours, excluding the time required for the journey to the magistrate's court. Now, what are the requirements to produce the accused? The accused must be produced before a magistrate within 24 hours as stated earlier from the time of his arrest. This can be any magistrate, whether they have jurisdiction over the case or not. Now, this is important. I again repeat, this can be any magistrate, whether they have jurisdiction over the case or not. This change simplifies the process and ensures there are no delays in the production of the accused, protecting their rights against unlawful detention. Now, this magistrate has a jurisdiction or doesn't have a jurisdiction has been specified in this section. In the BNSS 2023, section 167 of the CRPC, which governed the extension of detention, is now updated to section 187. Let's walk through a scenario to understand how this process works in practice. Now, arrest made without a warrant. A person is arrested by a police officer without a warrant based on suspicion of committing a crime. Step 2, documentation and timing. The clock starts ticking from the moment of arrest. It is crucial that the police officers begin preparing to produce the individual before a magistrate within 24 hours, excluding any time taken for travel to the court. Now, step 3, producing the accused. The police must present the accused before a magistrate within the prescribed time frame, even if the magistrate does not have jurisdiction over the case. This ensures the legal safeguard against unlawful detention is upheld. In the new law, the section dealing with extended detention, previously known as section 167 of the CRPC, is now section 187 in the new law. This section allows for special orders from a magistrate if circumstances require the detention of the accused for more than 24 hours. The magistrate before whom the accused is produced will ensure that the individual's rights are protected and the legal procedures have been followed. This includes verifying that the 24-hour rule has been respected. Now, a very important topic, that is the integration of technology in legal processes. Chapter 30. Information to the police, and a couple of important changes that have been made in the new law. Registration of zero FIR has been made mandatory, that is, the registration of an FIR for offences irrespective of the jurisdiction of a police station. Every citizen from 1st of July 2024 has acquired a sort of legal right for giving information about the cognizable offence by electronic communication also. If by electronic communication, it shall be taken on record by the concerned police officer on being signed within 3 days by the person giving it. I repeat, if it is given by electronic communication, it shall be taken on record by the officer on being signed within 3 days by the person giving it, and the substance thereof shall be entered in a book to be kept by such an officer in such form as the state government may by rules prescribe in this behalf. Other important changes in FIR registration by GRP, let's have a look. Women police officers or any woman police officer shall record the statement of victims, females, in case of sexual offences. That is, offences section 64 to 71, 74 to 79 or 124 of Bharatiya Nyaya Sanhita 2023. What are these specific offences? Under section 64, punishment for rape. Under section 65, punishment for rape in certain cases, that is against a female child under age of 16 years and against a female child under age of 12 years which attracts a death penalty. Under section 66, punishment for causing death or resulting in persistent vegetative state of victim. Under section 67, sexual intercourse by husband upon his wife during separation. Under section 68, sexual intercourse by a person in authority. Under section 69, sexual intercourse by employing deceitful means which will include inducement for or false promise of employment or promotion or marrying by suppressing the actual identity. Under section 70, gang rape. Under section 71, punishment for repeat offenders. Under section 74, assault or use of criminal force to women with intent to outrage her modesty. Under section 75, sexual harassment. Under section 76, assault or use of criminal force to women with intent to destroy. Under section 77, voyeurism. Under section 78, stalking. Under section 79, word, gesture or act intended to insult modesty of woman. And lastly, under section 124, voluntarily causing grievous hurt by use of acid, etc. For the first time in the procedural code, a provision has been made that for certain select offences which are punishable for 3 years or more but less than 7 years, now the officer in charge of the police stations, including GRP police stations, has been given this discretion that instead of directly registering an FIR, if they think the information is ambiguous or not very clear, they may first decide to conduct a preliminary inquiry. But for that, they will have to obtain permission of the officer of the rank of DSP or above. Therefore, Section 173 Clause 3 of the BNSS now formalizes the preliminary inquiry before it be conducted with the prior permission of an officer not below the rank of Deputy Superintendent of Police. In the event that the person against whom an offence under Section 64, 65, 66, 67, 68, 69, 70, 71, 74, 75, 76, 77, 78, 79 or Section 124 of the Bharatiya Nyaya Sanhita 2023 is alleged to have been committed or attempted, is temporarily or permanently mentally or physically disabled, then such information shall be recorded by a police officer at the residence of that person seeking to report such offences or at a convenient place of such person's choice in the presence of an interpreter or a special educator as the case may be. The recording of such information shall be videographed. The police officer shall get the statement of the person recorded by a magistrate under clause A of subsection 6 of section 183 as soon as possible. A copy of the information, clause 4 of the BNSS has expressly provided the option of making an application to the magistrate under section 175 clause 3 of the BNSS if the FIR is not registered by the concerned police officer, even after the intervention of the Superintendent of Police. These were some points related to the registration of FIR. Now let's focus on use of technology during scene of crime investigation. Procedure of investigation, recording of statement. In relation to an offence of rape, the recording of statement of the victim shall be conducted at the residence of the victim or in the place of her choice, and as far as practicable, by a woman police officer in the presence of her parents or guardians or near relatives or social worker of the locality, and such statements may also be recorded through any audio-video electronic means, including mobile phone. Now this is a very specific, victim-centric section. Now we come to procedure of investigation, section 176. On receipt of every information related to the commission of an offence which is made punishable for 7 years or more, the officer in charge of the police station shall from such date as may be notified within a period of 5 years. I repeat, within such date as may be notified within a period of 5 years by the state government in this regard, cause the forensic expert to visit the crime scene to collect forensic evidence in the offence and also cause videography of the process on mobile phone or any other electronic device. Provided that where forensic facility is not available in respect of any such offence, the state government shall, until the facility in respect of that matter is developed or made in the state, notify the utilization of such facility of any other state. Now, use of technology in summon. The new law has brought significant updates to the CRPC regarding the issuance and service of summons, particularly focusing on electronic means of communication. This is a very healthy step in the modern times, in this digital era. The forms of summons and how they are to be served is mentioned in section 61 and 62 of the CRPC, which has now been replaced and has been mentioned in section 63 and 64 of the new law, that is the BNSS 2023. Under the old provisions, summons were typically served in writing, bearing the court seal. However, with BNSS 2023, a significant change has been introduced. Summons can now also be issued in the form of electronic communication, such as encrypted emails or other electronic methods, with the court seal or digital signature. Section 63 clause 2 of the new law states that the summons may be issued electronically with the image of the court seal. I repeat, image of the court seal or digital signature. Section 64 of the new law states that police stations or court registrars must maintain a register with contact details such as email addresses and phone numbers. BNSS 2023 introduces a new provision for approving the service of summons issued electronically. All summons served through electronic communication under section 64 to 71 are considered duly served, and a copy must be attested and kept as proof of service. Similarly, in case of service of summons on witnesses by post and electronic means, section 71 clause 1 of the BNSS 2023 states that the witnesses can be summoned through electronic communication or registered post. Section 71 clause 2 states that if delivery or refusal to receive are proven, the summons is considered served. The changes introduced in the BNSS 2023 aims to modernize and streamline the process of issuing and serving summons, making it more efficient through electronic communication. As RPF and GRP personnel, it is crucial to stay updated with these legal provisions to ensure that the processes to compel appearance are followed correctly. As per section 183, if the person making the statement is temporarily or permanently, mentally or physically disabled, the statement made by the person with the assistance of an interpreter or a special educator, as stated earlier, shall be recorded through audio-video electronic means, preferably by mobile phones. Similarly, recording of search and seizure proceedings through audio-video electronic means is a new addition through section 105. Being a new provision added to the Sanhita, it addresses the search of a place and seizure or taking possession of any property, article or thing. The outline process also applies to section 185 BNSS, search by police officer, which includes the following steps. Firstly, preparation of a list of all seized items. Second, signing of these lists by witnesses. Third, recording the preparation and signing process through audio, video, electronic means to ensure transparency. 4. Promptly forwarding this recording to the district magistrate, sub-divisional magistrate or judicial magistrate of the first class as the case may be. Now this newly added section again reiterates focus of the new act on use of technology for ensuring transparency in police investigative procedures. According to this section, any search or seizure must be recorded through audio, video, electronic means. This recording should include the list of seized items and the witness's signature on the seizure memo. Furthermore, the police officer must promptly forward this recording as stated earlier to the concerned magistrate as the case may be. Now this section pertains to searching a place with or without warrant and does not cover the search of an individual. In cases of special acts and videographer before proceeding. Similarly, as per section 185 clause 2, a police officer shall, if practicable, conduct the search in person, provided that the search conducted under this section shall be recorded through audio, video, electronic means, preferably by mobile phones. Furthermore, section 497 specifies that when any property is produced before a criminal court or magistrate during an investigation, inquiry or trial, the court or magistrate must within 14 days, I again repeat, within 14 days, prepare a statement describing the property as specified by the state government rules. They must also photograph, which is mandatory, or if necessary, videograph the property using a mobile phone or other electronic media. Now it is optional to videograph but mandatory to photograph. Within 30 days of preparing the statement and taking the visual records, the court or magistrate shall order the disposal, destruction, confiscation or delivery of the property as specified. In chapter 29, it is prescribed that trial and proceedings may be held in electronic mode through section 530, which is a new addition in BNSS 2023. This is another healthy development. Section 530 mandates conducting trials and proceedings in a manner that aligns with technology, using electronic communication or audio-video electronic methods. Also under section 193 clause 3, subclause 1 of the BNSS, the police officer in charge must forward the investigation report to the magistrate, now allowed through electronic means also. So the new law provides a choice that instead of supplying the copies or police report and documents in a physical form, if the police officer supplies the same on an electronic device in an electronic form, it will be considered as duly served. Additionally, the report must include the sequence of custody in case of electronic device. In the line of victim-centric approach, to prioritize the victim's interest, section 193 clause 3 subclause 2 requires updating the informant or victim on the investigation's progress within 90 days. A very healthy development. A time frame not specified under section 173 clause 2 subclause 2 of the CRPC. Similarly, while section 173 clause 8 of the CRPC did not specify a timeline for further investigation after filing the charge sheet, section 193 clause 9 of the new law sets a 90-day period for further investigation, with any extension requiring court's permission. Very significant development. Time-bound trial. This aims to prevent abuses of police officers, ensuring accountability and avoid unnecessary delays in criminal proceedings. To summarize, Section 530 enables the use of electronic modes in various legal processes. Embracing technology enhances efficiency, accessibility, and justice. Our responsibilities include learning to use these technologies, ensuring compliance, and maintaining ethical standards. Challenges exist, but can be mitigated through preparation and adaptability, and also through right training. By integrating these practices, we contribute to a modern, effective justice system that meets the needs of our society. Technology is reshaping the way we operate. It's an opportunity for us to improve our services and better serve the railway community. I encourage all of you to raise these changes proactively. Witness Protection Scheme, it's a new addition in the new law. Section 398 of the BNSS requires each state government to formulate and announce a witness protection scheme. Recently, Assam government has notified a witness protection scheme. In the scheme, 3 categories of witnesses who can be provided protection based on the threat analysis report. The witness protection measures ordered shall be proportionate to the threat and shall be for a specific duration, not exceeding 3 months at a time. Threats may include ensuring that witness and accused do not come face to face during investigation or trial, monitoring of mail and telephone calls, companies to change the witness's telephone number or assign him or her an unlisted telephone number, installation of security devices in the witness home such as security doors, CCTV alarms, fencing, etc., concealment of identity of the witness by referring to him or her with the changed name or alphabet, emergency contact persons for the witness, close protection, regular patrolling around the witness's house, temporary change of residence to a relative house or a nearby town, escort to and from the court and provision of government vehicle or a state-funded conveyance for the date of hearing, holding of in-camera trials, allowing a support person to remain present during recording of statement and deposition, etc. Protection of identity during trial is also to be ensured. Relocation of witness. Based on the threat analysis report, a decision can be taken for relocation of the witness by the competent authority. The competent authority may pass an order for witness relocation to a safer place within the state or territory of the Indian Union, keeping in view the safety, welfare and well-being of the witness. The expenses shall be borne from the newly created Witness Protection Funds. These are very healthy developments ensured by the Assam. By addressing the needs of various stakeholders and at the same time incorporating modern practices, it aspires to build a robust framework for railway security. Thank you for a very patient hearing. Jai Hind.